it is that the second defendant, Mr. Chalmers, should or should not have been doing that renders him in some way liable. But bearing in mind, my lady, that the proclamation requires theft, criminality, willful misconduct, maladministration, all of these issues, they don't even make the allegation of these issues. So they say that he has this responsibility, which hasn't been established, for financial oversight. And as a fact, it goes to show how little the plaintiffs actually know that Mr. Chalmers has in no way been involved in the administration and day-to-day running. He's an honorary member of the board. He's not a director. They say he's an honorary life member of the board of directors. That has not been established. He is not a director. He's an honorary member of the board. That is all he is. And the reason for that is because of his years of service, that it is precisely that. It's an honor that we want to recognize you as having made a contribution to this. But he has had no day-to-day functions whatsoever. So that should be a very easy issue to dismiss. And in fact, I will go so far as to say there's case authority by Honorable Acting Justice de Villiers, where he talks about the model litigant, that when the state, wielding the authority of our taxpayers' money and all their resources, brings a claim, they need to do it in absolute good faith, and they need to be a model litigant. My lady, it is absolutely disgraceful that a man who served his community as an NPO years gone by now gets dragged into a matter where he's nothing to do with it whatsoever, using the resources of the state. It is utterly unacceptable, my lady. And that is why an attorney-client cross order must be granted. We then go on and says the third defendant commenced with the duties as administrator of the third defendant on 8 November 2016. The majority of the claims forms following his appointment were signed by Mr. Bosman, the third defendant, and which signatures that serve to confirm the accuracy of such claims. But let me say as follows, my lady. Her ladyship heard evidence that it is in fact the department full knowledge of the fact of numbers. He puts, because that's how the SLA works, it's based on the number of heads in the facility. He puts the patient details that clearly cannot be correct, that the mere fact of him signing it. Her ladyship will no doubt be aware that it happens all the time, that parties sign an affidavit under oath, and then it turns out that they're mistaken. Does that mean that they attempt to court? Of course not. It goes towards whether their bona fides believed that to be correct. And within the purview of the fact that the department fills out the financial issues on the form, I'd like to know what brings about liability for Mr. Bosman, especially within the purview of the fact that there are various amounts that are discussed and agreed as constituting an overpayment, reconciled and paid back to the department by Mr. Bosman. He's acting as an administrator in absolute good faith. I make no concession. I'm vociferous about this. I make no concession whatsoever that Mr. Bosman has made an error in the way that he has administered these funds. It has been absolutely fastidious in the way that he's managed these funds. However, even if Mr. Bosman had made a bona fide, it still hasn't been established.
But the fact that you would sign a blank document without knowing amounts?
But that's not the fact, my lady. That is the process imposed upon us. That is the process imposed upon Mr. Bosman by the department in terms of their standard operating procedures. It is not Mr. Bosman that says, here's a blank form, fill it out at your will. They determine to Mr. Bosman how he goes about this, and he completes the patient details. They then fill in the amounts based on their determination of the amounts that are owing.
Okay.
But my lady, let me just draw your attention. It's to two things. First of all, that is signed at the offices of the Department of Health, and that was common cause from the evidence. Mr. Bosman goes there and signs there in their presence. But the second issue is that these overpaid amounts arise from the fact that the department was unilaterally withholding amounts that should have been paid on a month-to-month basis. The donations that San Michele get from third-party donors, from the community acting in good faith to try and assist people to whom the state has a duty to assist, they deduct these funds. Mr.
Lose you soon.
I have the same issue, my lady. Perhaps if we do lose each other, what we'll do is contact your ladyship's registrar and make the appropriate arrangements. My lady, I was on the issue of There's an important point to raise with regards to the filling out of that. This is no criticism.
No. I was talking about the two, what provisions in the SLA agreement regarding donor funding, because you seem to say that those they are amount. They are, would you understand that the donor funding that you have not returned?
In a friend where he says it's state monies that we're recovering. With all due respect, my lady, how dare the state come and say that monies that are donated for people donating to a cause that they believe is a good cause, and the state says we must come and take that money to fiscus. Absolutely unacceptable. It is contras bonus mores. It is disgraceful.
What is part of those funds and keeping these? Because remember, the entity that you're dealing with here in the state. So what does the SLA say, the service level agreement, regarding surplus funds? Does the surplus funds include only funds that were paid by the plaintiff, or does it include donor funds or exclude donor funds?
My lady, in terms of that question, we have to look at Natal Joint Pension Fund.
Yeah.
There actually can't be an overpayment of state funds if the contract is actually applied properly and if it is administrated by the department properly. I say that for the following reasons. The department says we will give you a stipend per head per month because you are looking after these patients where we should. But if for some reason you don't spend that money, you must pay it back to us. And that should be obvious. Now, the point is that the money that they give is actually not sufficient, but they do get private donor funding. Now, the point is this, my lady, it is a matter of the prerogative of San Michele on how to administer those funds. So they take donor funding and they say, we're going to keep this donor funding because it actually does happen for other reasons that, first of all, we can't meet our day-to-day expenses. But second of all, it happens where the state doesn't actually pay us the money that we need in terms of the service level agreement. But there's people laying in beds that need medication, they need food, they need care. We can't leave them. So we will take donor funding and we will utilize that donor funding to cash flow, to manage the cash flow, because otherwise these people are going to die.
Is that in terms of the service level agreement with the plaintiffs? It can't be because
it has to be, my lady.
But is it there? I can't remember now what the service level agreement said as far as donations. But surely the donations have to be used, and then a determination be made whether you require further funds. Is it not?
No, not at all. Okay. Not at all, my lady. And I would suggest that is an absolutely abhorrent interpretation of the service level agreement. Is unacceptable because the state, I ask these questions of the witnesses. There's an obligation constitutionally on the state to provide healthcare, basic healthcare and emergency healthcare to people who require that funding. That is precisely the position that the patients in San Michele find themselves in. The state has that duty, but the state doesn't do that. So San Michele as a not-for-profit organization does it, and the state says, we realize that you are actually doing this on our behalf, so we give you a stipend. Although that stipend is actually not sufficient, that's the stipend that we are giving you. It is unacceptable where a donor says, I'm entitled to give money to care for people that are actually not able to care for themselves, and the state may be giving insufficient, and I'll get a tax benefit for that, and I will give you that money. That is not state money, and it is the entire prerogative of San Michele to manage that money as they see fit. So if San Michele says, we're going to put that money in the bank account, and we're going to keep that money to fund the cash flow requirements, I might hasten to point out, caused by the fact that the government is in default of their constitutional duty to care for people in a hospital bed because they don't give us the money in terms of the service level agreement that must be paid. That means we have two options. Either we let the patient die because there isn't money to add food and other care that they need, or we take money that we hold in reserve to fund what the government should be actually giving to us to care for these patients, because it's actually their duty to care for these patients, but we're doing it on their behalf. So with respect, my lady, what is actually happening here is the state is then appropriating your donor funding and my donor funding and society's donor funding, which is given as a benevolence, and saying, we didn't pay you in the first instance, and you have to go and use your own money. But what we're going to do is, when we do eventually pay you what we should be paying you anyway, we want to take any additional funds that we say was a surplus, which may have been from donor funding. In fact, it is from donor funding. But it gets worse, because then what the state says is, we won't pay you for months on end until we go to a high court who forces us to pay you what we should have been paying you in arrears. But because we pay you 2 to 3 years later, we are then going to construe that because that money appears in your bank account 2 financial seasons later, we are going to say that that's an overpayment, despite the fact that we haven't paid you 2 years in the past, and then we want that money back. It is utterly abusive, and it is abhorrent. My lady is on mute.
Sorry, we're dealing with it. Sorry, we're dealing with an application for absolution. Do I have that version from the defendant regarding those amounts as they stand?
Yes, because it was conceded in cross-examination. So, my lady, let me put it this way. We have it from Mr. Pillay. Let me explain why. And we've gone away from the issue, and perhaps I can just stick to that issue and just deal with the pleadings. Let me not slavishly regurgitate it from a time point of view, but if I can ask your ladyship to consider the amended particulars of claim from paragraph 27 through to 39.
So where do we stand with these again, with the amended particulars?
My lady, the amended particulars is actually the particulars that a plea was delivered on, and those are the particulars that we've run the trial on.
So I take it then that it's amended to that. All right. That makes it easy.
Yes, it was amended, my lady. Quite right.
All right.
But because of the peculiar way in which the matter was dealt with at the outset, the exception remained alive. But I'm not focusing my attention on the exception. I'm simply saying that the case hasn't been made out in evidence or in pleadings at all, and there's no basis upon which a court can grant judgment. So for the purposes of concluding this issue, in respect of the second and third defendant, Mr. Chalmers, has played no function, no role whatsoever. And there's no evidence before her ladyship. In respect of the third defendant, Mr. Bosman has been doing his level best, and I might say has been doing an absolutely sterling job in managing the first defendant's affairs and keeping it afloat. Her ladyship will recall, although her ladyship constrained me and stopped me on the issue, I put to one of the witnesses that there was a health ombudsman finding which arose pursuant to the Isidamedi life controversy, which by now is notoriously well known, I might unfortunately say. And that health ombudsman said that San Michele is the very model of the way these NPOs should work. Her ladyship constrained me during that.
But that's CSA, yeah.
It actually wasn't, because I wanted to extract it from the public record, and it's notoriously well known. It's an ombudsman finding, but I don't need to rely on that for my absolution. I'm just pointing out, my lady, that there is evidence to suggest that not only is there no misconduct, but actually it has been run as a model. But the plaintiff is the one that must make out their prima facie case to show you what misconduct Mr. Bosman has actually done that would warrant him being personally liable. And there's simply, and this, we're constraining ourselves to the absolution now, my lady, but there is simply no evidence to suggest that Mr. Bosman has appropriated the money for himself, because my learned friend refers to the annual financial statements of San Michele, in which he says there's money there. At no point is the allegation made in evidence, or is the evidence provided that Mr. Bosman paid monies corruptly to third parties. The money's in San Michele, and they're saying San Michele owes this money back. And Mr. Bosman says, no, there was monies that was repaid to you legitimately on the SASSA grant and on an agreement of what was due and owing after a reconciliation took place. I don't owe you any money. San Michele owes you no money, because it's been repaid. Everything that you've overpaid through your poor administration has been settled. There's no monies due. And we're going to come to that as it concerns the third defendant right now. My learned friend seeks to place reliance on the annual financial statements. And my learned friend seeks to make something of a qualification in the audited financials, which says cash on hand. It is impractical to determine the correctness or accuracy of the cash received. My lady, we have to look at this with some common sense, some commercial common sense. The state says to you, we've paid monies in EFT amounts which are in the bank accounts. And Mr. Pillay says to you, I've gone through the bank accounts and here's all the money that we've paid. Nowhere does he say San Michele is paid cash from the state in cash, in actual notes. Nowhere is that said. There is donor funding. What that qualification means is cash on hand refers to donations that are received from members of the society or organization, whoever gives money, and it does not refer to money paid to San Michele by the state. And that is common cause on the plaintiff's own version, because the plaintiff says these are the amounts which were paid, which appear in their bank account. What that auditor means when he says it's not practical for us to determine those cash amounts, I submit, is that if there's cash amounts received that are then banked, it's impractical for him to go and try and find the person who gave the cash and to say, well, how much money did you give? Is it the correct amount? He just said, I'm not going to do that exercise. It is absolutely impractical for me to do that. But I will just point out, my lady, that is donor funding money. It is not money paid from the department to San Michele. The state does not have any claim to donor funding paid to San Michele. And that is what it means. But my lady, let me just point out the obvious, that it is unclear to me what exactly is sought to be made by auditor saying it's impractical amount of money that we paid. That amount of money appears in the bank accounts. So we don't even need to worry about what the auditor says about verifying these other amounts with respect. So that really just goes nowhere. It is common cause at paragraph 60 of my learned friend's heads of argument that donor funding is received. And I will take her ladyship to precisely what my learned friend says on that issue, which appears, I won't refer to the case lines reference, I know her ladyship doesn't have it, but at paragraph 60, what the first and second plaintiff says as per first defendant's annual financial statements for the year ended 31 March 2016, donations were received for the year in 2016 was an amount of 500,000 rand. The fundraising for the year 2016 was an amount of 384. And the should be patients fees received for the year 2016 was an amount of 137,000. Sundry income of amount of 16 and workshop income an amount of 16. That, my lady, is on what the state tells you is donations that were received. It is not a stipend paid in terms of the service level agreement. So what we have here is, on the one hand, the state comes to you and says it's state monies that we must recover in terms of the service level agreement, and we pay in terms of the service level agreement, but there's donations that are received from the public and from their own efforts, which is not regulated by the service level agreement, and we want that money.
So look at paragraph 63, and they refer to this as unused or unspent monies.
It's not unspent monies, my lady. It is utterly unacceptable. It is, in fact, disgraceful that the state would do this, because those monies, my lady, if you'll recall what happened, the department unilaterally said, we're not paying you anything. We're not paying you the stipend in terms of the service level agreement. The money is held in reserve for things that there are an abundance of expenses that San Michele have to meet, water, etc. And that's not payment of water to the municipality. It's creating reserves and JoJo tanks and the like, when you're running a huge facility and the municipality is not providing an adequate water supply, that they have to meet, which is not covered by the service level agreement. There are certain expenses that that facility needs. For example, my lady, you will recall there was evidence where meetings were held at San Michele with the department and other not-for-profit entities. And San Michele paid for those meetings because there was simply no other venue at which it can be held. That money does not and may not come from a service level agreement. It comes from monies that is generated by San Michele from donations. So the point of the matter is it is an utter abuse that the state says we're not going to pay you the service level agreement, forcing you to take what other steps and efforts you need to take to keep these patients alive and keep this organization afloat. But then when we do pay you the money, which we were obliged to pay you, albeit in an outside financial period, we are going to come back and say, you must pay that money back to us because it's unspent funds. I think Her Ladyship sees the picture here. My lady, we move forward. In terms of my learned friend's amount of 517,000 Rand, that is not the state's case. And I will go so far as to respectfully state that it is utterly disingenuous to come and state something differently. Mr. Pillay gave his witness evidence. He said, here is the amounts of money that the service level agreement paid to San Michele over that period of time. Here is the expenditure for that period of time, and therefore the surplus is that, and that is the amount that we are required to claim back from San Michele. What Mr. Pillay conceded is that he never considered the fact that there was a court order for historical amounts which were owing to San Michele, which were then paid into that financial period, and he conceded that to make a proper determination of what the amounts that might be owing to the state are, would have to actually go back outside of the period to see what amounts were due and owing and not paid, and then what amounts were received. He conceded that. And I said to him, so you can't actually tell us. And he said, no, I can't.
I'm aware of that concession.
So for my learned friend to now come and say, well, now on a different basis of donations that we received, there's this different amount and this is what we must be claimed. That is not the state's claim, and they are not entitled to that money on an interpretation. In fact, not even an interpretation. They're not entitled to that money from the service level agreement. What they are entitled to is that if it so happens that the state provides a stipend of 1,000 Rand a month per patient, and they only need 800 Rand a month, the 200 Rand a month must go back. But of course, that scenario doesn't happen because San Michele incurs more costs than what the state actually provides for them. And that's why they need donor funding. So what the service level agreement regulates is the stipend. It could be, although it's highly improbable and it doesn't happen in fact in these circumstances, that any surplus paid from the stipend that's not spent because they don't incur those costs, I concede and accept that that would have to go back to the state, but that is not the case. What San Michele does is they say the money that we receive from the state is insufficient to keep this entire facility running, and we do have donor funding, and we utilize that donor funding according to our managerial discretion, either to put it in reserves so that when you don't actually pay us the money, we can keep the thing afloat. And what the state is now doing is saying, yes, but that money which should actually be kept in reserve or utilized for other things that the service level agreement doesn't cover, you must now pay effectively your donor funding, you must pay it to the state. It is unacceptable. The service level agreement does not regulate donor funding. It regulates a stipend paid from taxpayer money. And they were not paying those monies. And that is why there's a surplus amount for a financial period, but not for the entire period. And with respect, my lady, we haven't had the opportunity to show you that, but the state hasn't established that there's money owing and what amount is owing. And there was a concession made that we could never establish that because we didn't do our job in terms of what the very proclamation says. It's at the first sub G of the annexure, which I read earlier on, which says that you actually have to go back and you actually have to go and look at those amounts. But let me take Her Ladyship to what Mr. Bosman explains. My learned friend says that this was not put to the witnesses. With all due respect, that was a misguided statement to have been made. Mr. Bosman says on his witness statement, it's at paragraph 74, on 11 October 2017, San Michel received a letter from the department addressed from Mr. Shai, acting chief financial officer at the time, claiming an apartment and must be paid back by San Michel. It needs to be noted that the amount requested and claimed was incorrectly calculated and did not correspond with the total subsidy paid to San Michel for the months of April, May, and June 2017. After a process of reconciliation with Mr. Mukabati, the senior financial representative from the Department of Health, it was agreed that the money required to be paid back to the department was the amount reconciled as 1.4 odd million rand, which constituted the April and May subsidy monies. The ladyship will recall that there was this court order and there were some overpayments. Mukabati further acknowledged that the department had continued to unilaterally reduce the monthly subsidy payments due to San Michel Home in terms of the service level agreement, and an amount of 680,000 rand was recognized as being an amount still owing to San Michel, and hence the arrival of the figure of 1.4 million rand. In terms of the agreement after reconciliation, the amount of 1.4 million rand would be paid back by San Michel in 2 equal installments of 708,000 rand. The reconciliation and agreement between the department and the leadership